I'm no stranger to criticizing prosecutors that use the win by any means necessary mentality. And here I think we have a story that illustrates why that is. We're going to look at this story from Genoa Township, Michigan, and see what happened. Yesterday, a man accused of sexually assaulting a 17-year-old girl on a golf course in the Genoa Township was found not guilty on all counts at a second trial. So this is a retrial. Back in March of 2020, during Zachary Lally's first trial, a jury actually convicted Lally. They found him guilty of 3 counts of first-degree criminal sexual conduct causing personal injury, 1 count of second-degree criminal sexual conduct causing injury, and 1 count of assault with intent to commit sexual penetration. The first jury did find him not guilty on 1 count of first-degree criminal sexual conduct. But sentencing was delayed to allow some time for motions, so we're going to get from what happened in 2020 after this conviction to present day, where now, after a retrial, Lally is acquitted. First, here's a summary of the details of the case from John King with WHMI. So, Lally was charged in October 2018 after he was accused of assaulting a teenage girl who was working at a concession stand at the Oak Point Country Club golf course in Genoa Township. According to her testimony, Lally and another man bought beer from her and then left to go golfing. She said Lally later returned and that she got into a golf cart with him to go search for a deer that had been spotted earlier. She said when they got to a stand of trees, Lally forced himself onto her, at first trying to kiss her, but then pushing her to the ground and raping her. Afterward, she fled in the golf cart back to the concession stand, where she found Lally's phone and called his friend. The two of them proceeded to go back and pick up Lally as she was concerned about his state of mind. But she said when they returned to the concession stand, Lally again tried to assault her. However, he was interrupted by other club members, one of whom drove her back to the clubhouse. When authorities confronted him about acting belligerently at the golf course the night of the incident, Lally admitted that he had had a significant amount of alcohol. And at this point in time in 2020, Lally was in Livingston County Jail pending sentencing, where he was facing up to life. And thanks to Kayla Dougherty from Livingston Daily, we have some coverage about what happened at the September 2020 evidentiary hearing with the motion for a new trial. The defense's key argument is that a Livingston County assistant prosecuting attorney lied during the trial that took place earlier that year. The prosecutor did everything she could to secure a conviction, whether it was ethical, whether it was legal. I have a minister of justice lying to the jury in a capital case. And this is from defense attorney Roland Sizemore. Tom Kaiser, another defense attorney, had claimed in the written motion that Pamela Moss, the prosecutor, committed several instances of misconduct during the jury trial of Zachary Lally. Kaiser claimed that Moss coached and threatened witnesses, prompted witnesses on the stand, withheld evidence, intimidated Lally's family, and suborned perjury. At this hearing, Sizemore's testimony began on Monday and continued into Tuesday, so it sounds like he had a lot to say. Sherry Petty also testified that she saw Pamela Moss prompt witnesses throughout the 2-week trial. Petty described Moss's actions as follows. As she stood at the podium, Pamela would stand there, and I watched her hair move ever so slightly back and forth and up and down. Petty said the movements were very slight but apparent. Now moving on to suborning perjury. Another instance surrounds a conversation between Moss and the lead investigator in the case, Livingston County Sheriff's Detective Greg Thompson. The television in the courthouse's attorney lounge was streaming live from Hattie's courtroom on March 4th. Again, we're in 2020. That day, Lally's trial attorneys, Sizemore and Katie Livingston, witnessed a conversation over the video stream between Moss and Thompson. Sizemore says, "We both stopped talking and watched the television, still from the table." Moss and Thompson, so prosecutor and lead investigator, began to talk about what lab testing was done of Lally's body or his clothing and why certain tests weren't done. At that point, Sizemore said Livingston began recording the broadcasted conversation on her cell phone. Sizemore said, "I heard Detective Thompson say something like this. I remember we talked about it, but I can't remember what we decided." Decided is interesting language if you ask me. Sizemore said Moss and Thompson moved towards the counsel bench and continued talking. Her voice lowered to almost a whisper. "You just tell them based on his client's statements that we felt we had enough evidence to convict him, so we didn't need to send it in," he testified. On this recording, Livingston, this is one of the defense attorneys, can be heard saying, "She is literally telling him exactly what to say." After Livingston and Sizemore confronted Moss about the conversation, the 3 attorneys went into a meeting room to watch the video. There, Moss, this is the prosecutor, told Sizemore, the defense attorney, "You know, Roland, this is eavesdropping. This is a felony." And this is coming from testimony from Sizemore that day at that hearing. Neither Livingston nor Sizemore have been charged with a crime. So now let's look a little bit at the prosecution fighting back, what their counter arguments are. So, Assistant Oakland County Prosecutor Danielle Walton argues that the defense lost its opportunity to claim prosecutorial misconduct because the matter was addressed and resolved during the trial. It's noted here that Assistant Prosecutors Danielle and Paul Walton were appointed by the Michigan Supreme Court as special assistant prosecutors for the case following Kaiser's motion. Paul Walton argues that neither Sizemore nor Livingston brought the recording to the court's attention before Thompson's testimony. It came up while Thompson was on the stand. Walton also referenced Sizemore's statement during the March trial, in which Sizemore said, "I want to be very clear to the court. I don't think Miss Moss has done anything inappropriate. I'm not saying that." Now, a quick pause here, but what happens when an attorney on either side, just generally speaking, casts an aspersion on another attorney in the presence of the jury? There's going to be an objection there that's not considered appropriate behavior. And here, the special prosecutor Walton is referencing that from trial as an opportunity to say, hey, even Sizemore at some point said that he didn't think that Ms. Moss had done anything inappropriate. But while testifying at this hearing for a new trial, Sizemore says that the statement wasn't 100% truthful. In other words, when I said, I want to be very clear to the court, I don't think Ms. Moss has done anything inappropriate, that wasn't truthful. I did think she did something inappropriate, but I didn't want to say that in court. So after testimony from Sizemore, and again, shout out to Kayla Dougherty for these updates, we end up getting testimony at the hearing from Chief Assisting Prosecuting Attorney Pamela Moss herself. Again, we're still back in September of 2020. She testifies that she did not withhold evidence, prompt witnesses, or threaten defense attorneys during the jury trial of Zachary Lally. I assume this is in reference to the, this is eavesdropping, this is a felony comment that Sizemore testified about. Moss said she did not call a witness a liar nor prompt the lead investigator in the case, Livingston County Sheriff's Detective Greg Thompson, while he was testifying. What I can say unequivocally is that I was in no way trying to influence the officer, Moss testified. Now we get an extra detail here that I think is critical. So we have this same detail that in this recording, Moss can be heard telling Thompson, the lead investigator, just say that we discussed it, and based on his client's statements, we felt we have enough evidence without it. This is why they didn't send the clothing off for testing. Thompson, during the trial, testified a week later that Moss did not instruct him on how to answer questions about the testing. So now we have the lead investigator being asked, were you instructed by the prosecutor on how to answer questions about the testing? And on the stand under oath, lead investigator says, no, Moss, the prosecutor did not instruct me on how to answer questions about the testing. So that's probably an oops. Then at this September evidentiary hearing, Moss testifies that Thompson was telling the truth because, quote, I didn't tell him what to say. Moss said she found out about the recorded conversation during Thompson's testimony when Sizemore asked Hattie to approach the bench. Now let's look at the judge's findings and see why a new trial was granted. And this is coming from WHMI reporter John King. We do get this detail here that, after they approached at the bench and trial resumed, that Detective Thompson gave the exact answer. The wording, the verbiage that's heard in the recording, the just say we discussed it, just say that we discussed it. He gives that exact answer when questioned by Moss on presumably direct, and then again the next day while under cross-examination by Lally's attorney Sizemore. Just said the same exact words 3 times, one in the recording, once on direct at trial, and again on cross-examination at trial under oath. But let's get to the judge. Hattie later determined that Moss improperly influenced, that's in quotes, the detective's testimony, and that the testimony in question was, quote, false, and that Moss knew it was false. This would be suborning perjury. Further, Judge Hattie determined that statements from Moss' closing arguments that male DNA had definitively been detected on evidence in the case was not supported by the facts, and that in reality, a crime lab expert had only testified that such findings were possible but not conclusive. Hattie called it a false statement to the jury related to, quote, critical information at issue in the case, the DNA evidence. Based on those conclusions, Hattie said Lally had been denied a fair and impartial trial and a new trial was warranted. The prosecution tried to appeal this decision, but the Michigan Court of Appeals upheld Judge Hattie's rulings. Even though the prosecution tried to appeal this to the state Supreme Court, the appeals court didn't even want to hear the issue. And then back to present day, where we started with this video, we have a jury acquitting Zachary Lally on all counts at this retrial. And according to Tess Ware, the jury deliberated for about 3 hours yesterday, July 16th, before reaching this verdict. So that's the story of how we have an acquittal on a retrial for somebody who was initially convicted on almost all counts at the original trial, with the judge finding that the state did play unfairly in the first trial. And my own personal opinion is when you play to win by any means necessary, it can backfire. And I think this is an example of that. And it's a bit of butterfly effect, right? Who knows if there even would have been a retrial if that conversation that was overheard wasn't recorded. But let me know what you think, either about this case specifically or just generally speaking. Wrongful convictions suck, victims not getting justice sucks. And when prosecutors don't play fairly, who actually wins?